Greetings and welcome to the Constitutional Law Series presented by Kautilya Society at NUSRL Ranchi. I am Arshdeep.
And I am Anshita. In today's episode, we'll be examining the Nari Shakti Vandan Adhiniyam, the Constitution 106th Amendment Act 2023, not as a political event but as a constitutional instrument providing one-third reserved seats for women in the lower house.
We'll see what it does to the structure of the Constitution, which articles it engages, and where it stands legally. We'll also discuss the April 2026 collapse of 131st Amendment Bill. The first thing that comes to our mind with reservation is Article 14 that guarantees equality to all and allows affirmative action.
Exactly, Arshdeep. Derived from the American Constitution, Article 14 holds a positive concept that treats likes alike, while it forbids class legislation as held in State of West Bengal versus Anwar Ali Sarkar 1952. It permits reasonable classification, isn't it?
Yes, Anshita, for validity, the classification must satisfy two tests: intelligible differentia and rational nexus with the objective. Women's reservation in Parliament clearly passes both and promotes substantive equality.
Adding to that, Arshdeep, Article 15 prohibits discrimination on grounds of sex, but what we focus specifically is Article 15 Clause 3 that expressly empowers the state to make special provisions for women and children.
And what have the courts ruled in this regard, Anshita?
In Government of Andhra Pradesh versus P.B. Vijay Kumar 1995, the Supreme Court held that while discrimination solely on sex is invalid, quotas for women to uplift them are permissible under Article 15 Clause 3. This is further supported by Article 16 on equality in public employment and directive principles, Article 39 Clause A, 39 Clause D, and Article 42.
So overall, women's reservation is constitutionally grounded and aligned with the state's policy commitments. Now let's discuss the architecture of 106th Amendment Act.
It didn't just declare a goal, it re-engineered the representation framework by inserting three key articles. Article 330A reserves one-third seats for women in the House of the People, with one-third of SC/ST seats reserved for women from those categories. That means a quota within a quota. Article 332A does the same for state assemblies, and Article 239AA extends it to the capital of India, that is Delhi.
This addresses intersectional disadvantages faced by Dalit and Adivasi women. But how is it altogether linked to delimitation?
The most complex provision in the bill is Article 334A. It links commencement to the first census after 2023 and subsequent delimitation. It has a 15-year sunset clause, extendable by Parliament, and provides for rotation of seats with every delimitation and not with every new election.
So Anshita, this linkage to delimitation under Articles 81 and 82 creates a major constitutional tension between gender justice and federal equity. When was the last delimitation exercise held, Anshita?
The delimitation process was frozen in 1976 and again in 2001, keeping seat allocation based on the 1971 census to protect southern states that successfully controlled population through dedicated governance.
So Anshita, here comes the issue with the bill. If the freeze is lifted, northern states like Uttar Pradesh and Bihar will gain seats, while southern states like Tamil Nadu and Kerala will lose relative political strength. Southern states argue that this penalizes their progress in education, healthcare, and demographic management.
Arshdeep, the problem doesn't end here. The government has proposed expanding Lok Sabha to 850 seats on a pro rata basis so no state loses its current numbers. However, the 131st Amendment Bill did not increase Rajya Sabha's strength, which would alter the House ratio and strengthen Lok Sabha's dominance under Article 108 joint sittings.
This brings us to the April 2026 constitutional crisis.
The 131st Amendment Bill sought to fast-track reservation by linking it to 2011 census data for implementation by 2029. It proposed increasing Lok Sabha's strength to 850, giving Parliament power to choose the census and lifting the fees.
But Anshita, what happened in the House when the bill was presented?
On April 17, 2026, the bill was defeated. It received only 298 votes, falling short of the special majority required under Article 368. Opposition from southern parties, demands for OBC sub-quota by Congress and SP, and resistance to using the bill as a delimitation smokescreen led to its failure.
So the bill is defeated. But what are the reasons for its defeat and the challenges it is facing, Anshita?
Arshdeep, one major unresolved critique is the exclusion of OBC women.
Yes, Anshita. While SC/ST women have sub-quotas, OBCs, who form over 50% of the population, are left out. Proponents call it a double historic injustice and rely on the Supreme Court's triple test for local bodies.
The logic by opposition that the scenario of panchayats should apply to legislatures is also valid. However, the government's reply is that the constitution doesn't currently provide OBC reservation in parliament or assemblies, but the upcoming caste census may supply the required data for doing the same.
Besides all this, Anshita, the judiciary has also been active in this regard. In Jaya Thakur versus Union of India, the petitioner before Supreme Court has questioned the delay linked to a future census with no fixed timeline.
But Justice Nagaratna has only sought a timeline for the government, citing doctrine of separation of powers. Separately, in December 2025, the court used Article 142 in the Yogamaya MG case to direct 30% women's reservation in Bar Council elections.
Thus, judicial activism signals that the court views gender reservation as a necessary corrective.
So, Arshdeep, where does this leave us constitutionally?
The current situation is that the implementation remains deferred under Article 334A until after the 2027 census and delimitation. Experts expect the first 33% women quota Lok Sabha election around 2034, nearly 4 decades after the first bill in 1996.
Passing an amendment was only the beginning. The real constitutional work lies in reconciling federal equity with gender justice, resolving the OBC question, and ensuring substantive equality under Articles 14, 15, and 16.
Therefore, Anshita, the Constitution demands active pursuit of equality. The Nari Shakti Vandan Adhiniyam is a step forward, but the journey is far from over.
Now, that's a wrap on today's episode of Niti Samwad.
We'll be back with more such episodes analyzing the contemporary issues which you see and feel through a constitutional lens.
So, stay constitutionally curious till the next discussion.